Hello everybody. So in this video we are going to discuss a small topic, that is office of profit. So what on this slide what I have done is that I have not taken a final meaning of office of profit, because if I put up all the aspect of office of profit just for sake of definition, you won't be able to understand. So what we'll do is that on this slide initially we'll just take a logical meaning of office of profit that we can drive easily. Thereafter, once we have discussed every aspect of office of profit, then we'll have a final meaning of office of profit. So this office of profit is nothing but a combination of two words, that is office and profit. So any office that has any kind of profit attached with it, right, that office will be called office of profit, right? And because we are talking in relation to the government, so all those offices under Government of India, all the offices under state government, all the offices under local government will be called office of profit, right? So this is the basic, this is the crude meaning of office of profit, right? So here only we have taken only financial aspect, so only those offices which derive what you call financial, or which gives financial advantages, right? Those offices we are describing as office of profit. But later in the discussion you will see that even those offices which have any kind of influence, any kind of substantial influence, even those offices will be described office of profit. Now the point arises that why we are discussing this office of profit, why this office of profit is important, right? So when we were discussing the chapter of president, when we were discussing this chapter of vice president, when we had discussed this prime minister, right? So in those things, right, while discussing the eligibility criteria, if you remember, right, we had discussed that these people, president, vice president, prime minister, and even member of parliament, when we'll have discussion on parliament chapter, you will see that even member of parliament, so these constitutional functionary, right, be it president, right, be it vice president or elected representative, these people are not allowed to hold this office of profit, right? They cannot, means already they are president, means constitutional office they are holding, right? Vice president is also a constitutional office, then member of parliament, so they are already employed under Government of India, right? So other than this president office, president cannot hold any other kind of employment under Government of India. Similar thing is with vice president, similar thing is with elected representative, right? So why they cannot, means apart from, besides being member of parliament, or besides being member of legislative assembly, or besides being president, or besides being vice president or governor or whatever post, right, why they cannot hold government or any post under Government of India or a state government? Let us try to understand, right? Although the meaning is here, they are not allowed to hold other offices which may interfere with the independent functioning of their primary job. So what is the job? What is the job of primary job of member of parliament? To enact the laws, right? Here you may not be able to understand if I explain these things you theoretically, right? So let us move on the next slide and let us understand it through graphics, right? So these are member of parliament, and member of group of member of parliament in parliament is called legislatures, right? So these people are legislature and these people are executive. What is the job of legislature? The job of legislature is to enact the laws, right? What is the job of executive? The job of executive is to implement those laws. So if there is any scheme that has been designed by parliament, or if there is any scheme that has been designed by state assembly, right, those design will be done by these people, right? And these people will implement those laws, these people will implement, this executive will implement. So this understanding we already have developed after discussing the parliamentary system, after discussing salient feature of Indian constitution, after we were discussing that federal system. So this understanding about the roles of legislature and the role of executive we already have, right? But besides this enaction of law, besides designing the scheme, right, the other role that this legislature is, that other role is that they also hold these people, executive, accountable for implementation. So suppose 4,000 crore had been allotted for implementation of any scheme. Now those 4,000 crore is being utilized in the way that was intended or that was designed according to the law or not. So this is the job of legislature, that whether the scheme that is being implemented by this executive is being implemented in a manner that was intended by the law or not, right? And what are the tools available to these legislature? When we'll study parliament chapter, you will see there are certain devices that these legislatures have, devices like question hour. So in question hour, the first hour of parliamentary proceeding, right, these people can raise the question, and through these questions, right, where ministers are expected to publicly respond to those questions. So that questions are nothing but a tool. Through committee system, right? So again, committee system is nothing. In committee system, again, their reports are publicized, widely publicized, right? So these committee system is again a method to check on them, right? So the role that we have understood so far, that the legislature, apart from designing the law, apart from designing the scheme, they also have to control, they also have to hold these people accountable. Now take a case, right? If these what happens if these legislatures are allowed to hold any other government office as well? So let us suppose that this office, this is a LIC office. So this LIC office is under administrative control of executive, right? So executive has total control over LIC. Or suppose take another example, that is bail, or that is this hall, right, a defense organization, right? So these people, this executive has control over employment, means who will be CEO, who will be CMD of this government organization. This executive does have control. Now take a hypothetical situation where any of this MP or any of the MLA is allowed to hold, to be CMD or to be CEO of this government organization. And this government organization, when he is allowed to join this government organization is paying this member of parliament good amount, right, like 2 crores or 3 crores every month. In that case, this member of parliament who has got employment in this office, he or she will be obligated to the executive, right? And once he is obligated, because why he will be obligated? He will be obligated because the employment in this office is under control of executive. This executive can remove this person, this MP, from this office anytime. So he'll have some certain kind of obligation, certain kind of loyalty towards executive. Now let us try to understand. His primary job as member of parliament was to hold this executive accountable, but now because he is also allowed to hold the office, another government office which is under administrative control of executive, would he really be able to independently exercise his law making function? Would he be independently exercise his accountability tools? Would he be able to raise right questions? Would he be able to question the government? The answer is no. And that's why these people, member of parliament, president, vice president, governors, right, these people, these constitutional functionaries are not allowed to hold any kind of office under, means other than member of parliament, other than being president, other than being what you call vice president, they are not allowed to hold any other government office under the administrative, which is under administrative control of executive, right? So that was the concept, that is the underlying reason, right? Now let us take another example, right? So here again, the same member of parliament or member of legislative assembly. Why I am mixing these member of parliament and member of legislative assembly? Because even member of legislative assembly at state level are also not allowed to hold any office of profit. That's why I am mixing these two. So suppose these member of parliament or member of legislative assemblies are also allowed to indulge in private trading. So suppose a group of member of parliament, right, they are also running this Yadav Construction Private Limited, which is in construction business, right? So suppose budget is approved for the construction sector, for the construction of road in Uttar Pradesh, right? Budget is approved in tune of 4,000 or 5,000 crores, right? So tender is published by the government for the construction of road in Uttar Pradesh, right? These people, this company that is being run by member of parliament, this company Yadav Construction Private Limited, bags that tender, right? What will be the impact? So whenever next time the budget session will go, because they have this business interest as well. They try to, these member of parliament, the group of member of parliament who are running this Yadav Construction Private Limited, right, what will they try to do? They'll try to influence other member of parliament as well. See, their interest is already compromised, right? Their primary job was law making, right, to reduce the cost of government in the construction as much as possible. But because they are running this business, they do have this business interest as well, so their independent exercise of law making is already compromised. But they'll not stop only to that limit. What they'll try to do is they'll try to influence other member of parliament as well. Means they can promise anything, any kind of personal benefit, and they'll try to influence, and they'll try कि अगर पिछले बार 4000 करोड़ का budget approved for the road construction of UP हुआ था, right? So this time this budget should be increased in tune of 6000 crore, 7000 crore, so that जो उनका benefit है वो benefit increase हो, right? So here what you can notice is, you can notice the conflict of interest, right? They, same people are designing the laws, same people are approving the budget, and same people are bagging, getting the tender as well as a construction company. So what you can see is conflict of interest, and that conflict of interest is conflicting with the independent functioning, right, which they were supposed to do, right? Their primary function was law making. Their primary function, again I am repeating, to reduce the cost of the government in this construction as much as possible, right? But what they are doing is, they are in, because they are in business of this construction, right, they are trying to increase the cost of government for their own personal benefits, right? And that's why these people, member of parliament, member of legislative assembly or president, and this is another reason, this is another instance which cites that why these member of parliament or member of legislative assembly should not be allowed to participate in any kind of contract where government is involved, right? Because this is creating what you call this conflict of interest, right? So here MP MLAs approved the budget for the construction of road. A group of MLA are also running this Yadav. So whatever we discussed, right, this is nothing but this is in textual format, right? So you would have seen two cases, right? In the first case, you had this member of parliament holding government office that had created conflict of interest because he was obligated towards executive. The another case that you saw, that because of the contract, because of this private interest of member of parliament who are running this company, right, their independent functioning as member of parliament or member of legislative assembly, their that role as member of parliament and member of legislative is being compromised, and that's why these people, member of parliament or member of legislative assembly or president, vice president and governor, are not allowed to hold any other office which is under government of India or which is under what you call state government or local government. So while defining criteria for the disqualification of what you call member of parliament in article 102, this office of profit clause is clearly mentioned. So if any member of parliament was found, right, to hold any office of profit, even if, although to even contest member of parliament election, member of legislative assembly election, right, you should not be holding what you call office of profit. But if you cross that eligibility criteria, if nobody could know this what you call that you were holding office of profit, even in that case, once you have become member of parliament, right, even in that case, if you are caught that you are holding any office of profit, you will stand disqualified, right, and that disqualification decision will be taken by president in consultation with Election Commission of India. Similar eligibility criteria while we discussing what you call president office or vice president office we had seen. So this is the eligibility criteria under article 66 for vice president, and there as well we had seen that he should not be holding any office of profit under government of India or state government or local government, right? This was about vice president, right? Similar thing you would have seen while we were discussing the eligibility criteria for president under article 58, that is that he should not be holding any office of profit under government of India or state or what you call local government. So by now you would have understood this thing, that why these people, president, vice president, governor, member of parliament and member of legislative assemblies are not allowed, because that office of profit, the other office, that if they are allowed to hold that other office, will create a hurdle in the independent functioning as president, as member of parliament, as member of legislative assembly. Their primary function is to be MLA, to design the law, to be this president, right, to what you call preserve and protect the constitution. But because they are also holding a remunerative post under government of India, if they are allowed, of course, they are right now they are not allowed under the constitutional provision, but if they are allowed, right, I am again repeatedly saying, right, that if they are allowed, right, that will create hurdles, or that will not let them exercise independently their presidential function or their function as a elected representative, right. So I hope this thing would be clear to you. Let us see what we have done. Means, is there any act that we have made, right, we have enacted? So there is an act called Office of Profit Disqualification of MPs Act in relation to member of parliament, right. And the objective of that act is to avoid conflict of interest, the conflict of interest that we were discussing. To avoid conflict of interest, certain constitutional functionaries are not allowed to hold office of profit under government of India or state government or local government, right. So this we already have discussed, right. So this objective of this act that we have enacted, Office of Profit Disqualification of MPs Act, the objective was to reduce, to avoid this conflict of interest, right. But the problem with this law is that this law has not clearly defined that which all offices will fall under this office of profit, right, which all offices. There are certain offices that has been defined, but those number of offices are not exhaustive, and besides not being exhaustive, right, the other problem is that this law or this act that we have created, it allows parliament or state government to continuously revise that office of profit. And this revision provision that this act has given, right, various political parties or the parties which is in power, whether at state level or central level, right, they do use this provision of defining it again and again, or adding these office or removing these office for the political purposes, right. And that is the one drawback of this act. Let us see a few political cases of political misuse that has happened in past regarding this office of profit. So you see, in 2018, ECI, Election Commission of India, had recommended disqualification of 20 MLAs of Aam Aadmi Party to the president, right. And the reason of ECI, Election Commission of India, recommending disqualification of 20 MLAs of Aam Aadmi Party to the president, the reason was that these 20 MLAs had been given this parliamentary secretary post. So this parliamentary secretary post was not in existence earlier than this 2016, when this post was created, especially in Delhi, right. And the stated objective, why this office was created by the AAP, right, the reason, the stated objective was, see, there is something called if you are doing anything, there is something called stated objective and there is something called real objective, right. So the stated objective that was told by the government, the stated objective was that they will assist, means parliamentary secretary, those 20 MLAs will assist cabinet minister in their political constituency. So the stated objective, let me repeat it again, the cabinet minister sometimes is very occupied, right, but they do have certain obligations, certain responsibility towards their constituency as well, political constituency. They need to sit in those offices, they need to meet the citizens, they need to meet their voters, right. But because they are cabinet minister, they are part of council minister, right, they do have certain additional functions in secretariat, right. So because they are sitting in secretariat, because they do have that ministerial obligation, right, so they cannot perform their political roles effectively, and that's why these parliamentary secretaries were given to them, to these cabinet minister, right, who will look into their political function in their constituency, in their council of minister or cabinet ministers constituencies. But that was the stated objective. The real objective behind creation of this parliamentary secretary post was purely political. So let us try to understand. See, whenever either a state level or central level you have one particular party which is dominated the election or which has huge number of seats. So in case 2016 Aam Aadmi Party at the state level, that is at Delhi level, right, they had 67 seats out of 70 seats, right. So the problem is that you cannot please everybody, right. You cannot include all the 67 MLAs into Council of Minister, because if you know, there is something called 91st Amendment, and what this 91st Amendment did was that it reduced, it constrained the size of Council of Minister at central level as well as state level as well to 15%. 15% of what? 15% to the size of assembly or 15% to the size of Lok Sabha, right. So if I talk about at central level, you have how many seats? You have 543 elected seats, right. 545 total seats, those 2 seats of Anglo-Indian through nomination if I ignore, right, you have 543 seats. So at the central level, you cannot have Council of Minister exceeding more than 15% of 543. Similarly, at the what you call at the state level, so if I take example of UP Assembly has size of 402. If you ignore again 1 seat for the Anglo-Indian, right, so that will translate into 401 seat after deducting that 1 Anglo-Indian. So 15% of 401, right. So if at the central level, if I take this 15% of 543 would translate into somewhere 80 to 81, right, if my maths is not wrong, right. So you cannot, at central level, you cannot have more minister, the size of Council of Minister can't exceed this number. That is because of 91st Amendment. So the point is that size of Council of Minister cannot be expanded beyond a limit, right, and because you have more number of MLAs, because you have more number of MPs who needs to be accommodated, right, these state governments or political parties keep coming with the innovations, right. मेघालय में एक बार ऐसा हुआ था कि there were 60 MLAs, right, coalition के through government बनी थी, so सभी 60 के 60 MLAs को, whatever MLAs could have been admitted into Council of Minister, they were given position in Council of Minister, and whatever MLAs could not be accommodated in Council of Minister, this parliamentary post was created, and इस parliamentary post को क्या किया गया, इसको Office of Profit जो उनका स्टेट का लेजिस्लेशन है उसके डेफिनेशन से बाहर कर दिया गया कि भाई पार्लियामेंट्री सेक्रेटरी की जो पोस्ट है वो ऑफिस ऑफ प्रॉफिट में नहीं फॉल होगी, बिकॉज ऑफिस ऑफ प्रॉफिट में अगर रहने देते, राइट, दैट वुड हैव लीड टू वायलेशन ऑफ आर्टिकल 194, राइट, और वो एमएलए जो है वो सस्पेंड हो जाते, राइट, डिस्क्वालीफाई हो जाते. तो उसके लिए क्या इनोवेशन किया, और द सेम केस यू विल सी इन दिस दिल्ली केस as well, right. So let us turn back to Delhi case, and Delhi case से आपका मेघालय वाला केस क्लियर हो जाएगा, right. So पार्लियामेंट्री सेक्रेटरी का पोस्ट क्रिएट किया गया और 20 MLAs को पार्लियामेंट्री सेक्रेटरी बना दिया गया और बोला गया कि भाई ये लोग जो है वो कैबिनेट मिनिस्टर जो हमारे हैं, मनीष सिसोदिया, अरविंद केजरीवाल, बिकॉज दे कैन नॉट लुक इनटू द पॉलिटिकल फंक्शंस, राइट. सो उनके लिए ये पॉलिटिकल फंक्शंस देखेंगे. रियल रीजन वाज दैट बिकॉज 67 के 67 को आप काउंसिल ऑफ मिनिस्टर में नहीं रख सकते, राइट, एंड देयर आर सर्टन हैवी वेट मिनिस्टर जो कि काउंसिल ऑफ मिनिस्टर बिकॉज ऑफ 91st अमेंडमेंट नहीं लिए जा सके, राइट. तो उनको प्लीज करना है, राइट. तो उनको प्लीज करने के लिए पार्लियामेंट्री सेक्रेटरी का पोस्ट दिया गया, राइट. उनको भी वो व्हीकल, वो ऑफिसर सेक्रेटरीट में दिए गए, राइट, और उनको पार्लियामेंट्री सेक्रेटरी बना दिया गया. But the problem arose कि ये parliamentary secretary post were not existing in Delhi government prior to this 2000, and this led to media scrutiny and case finally landed to High Court. High Court से केस क्या होता है कि ये president के पास जाता है, because ultimate authority on deciding whether a member of legislative assembly of union territory or member of parliament, right, from the parliament is disqualified or not, that has to be taken by president. तो president के पास जाता है, लेकिन उससे पहले आप गवर्नमेंट क्या करती है, आप गवर्नमेंट पार्लियामेंट्री सेक्रेटरी के पोस्ट को OOP ऑफिस ऑफ प्रॉफिट के डेफिनेशन से बाहर कर देती है, राइट. दे हैव दैट स्पेशल असेंबली, और उस स्पेशल असेंबली में एक लेजिस्लेशन लाया जाता है और बोला जाता है कि पार्लियामेंट्री सेक्रेटरी की जो पोस्ट है, राइट, वो ऑफिस ऑफ प्रॉफिट के डेफिनेशन में नहीं आएगी, right. And this is how various state government and central government has played down, right. Whenever they fear कि कोई ऑफिस ऑफ कोई भी ऑफिस जो कि हमने अपने MLAs या MPs को दिया है, right, and that case can land into high court or supreme court, and that case can go to president, right. What they do is they amend office of profit act itself, right, and they exclude that post that has been awarded to their MLAs, that has been awarded to their MPs. They exclude that post, राइट, फ्रॉम ऑफिस ऑफ प्रॉफिट डेफिनेशन, कि ये ऑफिस ऑफ प्रॉफिट में आती ही नहीं है, राइट, बिकॉज दैट पावर हैज बीन गिवन टू देम, द स्टेट गवर्नमेंट और द सेंट्रल गवर्नमेंट. लॉ एक्ट अलाउड पार्लियामेंट और स्टेट असेंबली टू अमेंड दैट एक्ट and to add and remove that offices. And so because of this lacuna, you see that the Delhi government, right, they amended this office of profit act and excluded this parliamentary secretary post altogether from office of profit definition, right. फाइनली इस पे कोई डिसीजन नहीं हो पाया, हाई कोर्ट ने इंटरवीन किया, राइट, एंड हाई कोर्ट इंश्योर्ड कि इनका जो डिस्क्वालिफिकेशन है वो डिस्क्वालिफिकेशन ना हो. लेट अस सी अनदर केस, राइट. सो इन 2006 देयर वर एलिगेशन अगेंस्ट मैडम सोनिया गांधी एज वेल फॉर होल्डिंग office of profit. So she was already member of parliament for Raebareli, and member of parliament as per article 102 are not allowed to hold office of profit, and if they are found कि वो office of profit hold कर रहे हैं, they can be disqualified. So Madam Gandhi, what she was doing is that she was holding this NAC, National Advisory Council. So if you have read that Accidental Prime Minister book by Sanjay Baru, और मूवी अगर आपने देखी हो तो ये National Advisory Council, this was an extra constitutional advisory body. Although this was extra constitutional, but real power was lying with Madam Gandhi, means this body, National Advisory Council. All the policy decision like Manrega or any other policy decision, the real decision she was taking, and she was giving that file to Prime Minister office, and Prime Minister office just stamp लगाते थे, right. So this office was very powerful. Although it was argued when the case landed into the courts, right, it was argued that this office is not giving any kind of remuneration, government is not paying Madam Gandhi any amount, right, and that's why this office should not fall under the office of profit category. बट जब पॉलिटिकल क्लास को ये लगा कि कोर्ट कंप्लीटली कॉन्ट्ररी डिसीजन ले सकती है, ऑल्दो इट वाज सबजुडाइज, राइट, व्हाट दे डिड वाज, मींस यूपीए गवर्नमेंट इन 2006 व्हाट दे डिड वाज दैट ऑफिस ऑफ प्रॉफिट डिस्क्वालिफिकेशन और MPs एक्ट जो है, राइट, उसी को अमेंड कर दिया गया. और अमेंड करके क्या किया गया कि NAC, नेशनल एडवाइजरी काउंसिल, जिसकी चेयरमैन मैडम गांधी थी, उसको ऑफिस ऑफ प्रॉफिट के डेफिनेशन से ही बाहर कर दिया. एंड अलॉन्ग विद नेशनल एडवाइजरी काउंसिल देयर वर अदर 40 ऑफिसेज जिनको की ऑफिस ऑफ प्रॉफिट. देयर सोमनाथ चटर्जी, द देन स्पीकर ऑफ द लोकसभा, ही वाज आल्सो होल्डिंग एन ऑफिस ऑफ प्रॉफिट, तो उस ऑफिस को भी बाहर किया. सिमिलरली देयर वर अदर ऑफिसेज दैट वर being held by Madam Gandhi, other members as well, which could have led to the disqualification of other member of parliament as well, right. So 40 around offices को through this amendment, right, office of profit के definition को बाहर कर दिया गया, right. Finally this, when this amendment was sent after being passed by Lok Sabha and Rajya Sabha, this amendment finally when sent to President APJ Abdul Kalam, the late scientist, he was president, right. When it was sent for the assent to the president used suspensive veto, right, subscribed suspensive veto, and he urged parliament and rather speaker not to pass this amendment. Although president की जो वो थी, सजेशन थी या अर्ज था, उसको नहीं माना गया, and parliament ने इस ऑफिस ऑफ प्रॉफिट अमेंडमेंट एक्ट को फाइनली पास किया गया एंड दिस इज हाउ कैंडिडेचर ऑफ सोनिया गांधी मैडम एंड स्पीकर सोमनाथ चटर्जी एंड मेनी अदर मेंबर was saved by this office of profit amendment act. So this is how politically it has been used, right? I have taken just two cases, right? Delhi government wala case and Sonia madam wala case. There are n number of example. Meghalaya example earlier I was quoting. So 60 MLAs, the size of assembly is 60 MLAs, right? कुछ ऐसे circumstances बने, मतलब coalition का restructuring कुछ इस तरह से हुआ कि 60 के 60 MLAs को accommodate करना जरूरी था, right? Again what they resorted is कि पार्लियामेंट्री सेक्रेटरी की पोस्ट जो कि दिल्ली गवर्नमेंट ने बनाई थी, सेम पार्लियामेंट्री सेक्रेटरी पोस्ट वाज क्रिएटेड विद द सिमिलर रीजनिंग, अगेन स्टेटेड रीजनिंग, राइट? द रियल रीजन यू ऑलरेडी नो कि पॉलिटिकल होता है, राइट? यू हैव टू अकोमोडेट एवरी एमएलए और एवरी एमपी जो कि हैवी वेट होता है और जो कि नहीं मान रहा है, यू नीड टू प्लीज एज अ पार्टी सुप्रीमो यू हैव दिस रिस्पॉन्सिबिलिटी, बिकॉज इन दैट केस अगर आप नहीं एंटरटेन करते हो वो पार्टी ही बिखर जाएगी, right? So they, due to the political compulsion, these things has to be done, right? Why executive keep extending, keep amending this office of profit, right? So the reason is that political expediency we already have discussed in Meghalaya case, right? Huge majority or number of coalition partner, right? You have to please everyone but you have limited offices. Council of Ministers का size जो है 91st amendment ने limit कर दिया है, right? And that's why you need some kind of innovation, you need to accommodate those, you need to award member of parliament with what you call new offices has to be created and that's why this office of profit जो act है इसका political misuse होता रहता है, right? सो द क्वेश्चन राइजेस कि आप कैसे डिफाइन करोगे कि कोई ऑफिस जो है, ऑफिस पर्टिकुलर ऑफिस अंडर गवर्नमेंट ऑफ इंडिया वो ऑफिस ऑफ प्रॉफिट है या नहीं है. सो पॉलिटिकल क्लास से तो आप एक्सपेक्ट नहीं कर सकते कि भाई वो क्लियरली डिफाइन करेंगे कि ऑफिस ऑफ प्रॉफिट क्या है क्या नहीं है, राइट? सो इट इज़ बाय वेरियस जजमेंट फ्रॉम सुप्रीम कोर्ट, बाय वेरियस जजमेंट ऑफ हाई कोर्ट और various observation made by election of commission of India, right? These are three tests, these are three parameters on which you need to test the office, whether that office is office of profit or not. So the first test is that if that office is giving any kind of pecuniary interest, means financial interest, right? So if suppose I am a member of parliament and if I am holding any other than member of parliament being member of, if I am also holding any other office under government of India or state that is giving me any kind of pecuniary gain, financial gain, then I'll be disqualified, right? So that office will be called office of profit. But क्या सिर्फ पैसा ही काफ़ी होता है? Means if I am holding as a member of parliament, if I am holding any other office which is not giving me pecuniary advantage, but मैं decisions को, means executive के decision को या legislature के decision को अगर मैं influence कर सकता हूँ या कर सकती हूँ, right? Will that office not considered office of profit, right? So in NAC, National Advisory Council, that Madam Gandhi was holding, right, it was not giving her any kind of pecuniary advantage, but what this office essentially was doing is that it was influencing the policies of PMO, Prime Minister Office, right? So this office had become heavyweight, very powerful, even powerful than Prime Minister Office. So even this office may not be given what you call financial advantage to the holder, that is Madam Gandhi or any person who is holding. So even if any office is not giving financial advantage or financial gain, if it is of executive nature or if it has wide influence, right, that we saw in example of National Advisory Council, even those nature of offices will be called office of profit. And if any member of parliament or member of legislative assembly or what you call president or vice president or governor found holding any such offices other than the offices they are already holding, right, these people can be disqualified. So I hope योर कॉन्सेप्ट ओवर, ये टॉपिक थोड़ा सा लंबा हो गया था, राइट? बट आई होप ऑफिस ऑफ प्रॉफिट का जो कॉन्सेप्ट है डिटेल में आपको समझ में आ गया होगा एंड दिस विल हेल्प यू इन अंडरस्टैंडिंग दैट प्रेसिडेंट चैप्टर, वाइस प्रेसिडेंट चैप्टर, जहाँ की एलिजिबिलिटी क्राइटेरिया में वी वर कंटिन्यूअसली टेलिंग कि इफ ही इज होल्डिंग ऑफिस ऑफ प्रॉफिट ही शुड नॉट होल्ड ऑफिस ऑफ प्रॉफिट. सो आई होप ऑफिस ऑफ प्रॉफिट का कॉन्सेप्ट आपका क्लियर हो गया होगा. बाय बाय.